Hello class, this is chapter 11 in which we will discuss codes and ordinances. This chapter specifically discusses federal and state laws in the United States and how these laws influence the development and enforcement of fire-related codes and regulations. It also discusses the concept of jurisdiction and how it relates to the different levels of the court system. And it describes how personnel complaints brought to the department by the public and other members of the fire department are handled. Finally, this chapter discusses the legal components of fire prevention activities and legal considerations at emergency incidents. The objectives we're going to cover in this chapter are that we will give an overview of the types of laws in the United States, we will discuss the court system, describe how to handle personnel complaints, and discuss the legal components of fire prevention activities. We will also describe how fire codes are developed and discuss the legal considerations at emergency incidents. Codes and ordinances fall under broad description of laws. Laws are written and adopted on all three levels of the government, federal, state, and local. These are clearly laid out relationships among the different levels of government and their influence on each other. Gaining support for the restrictions and additional costs that the codes will require can be one of the greatest challenges to those who develop fire-related codes and ordinances. Politics plays an important part in the code creation and adoption process. At many points in our history, tremendous losses in lives and property have occurred as a result of a code restriction or a feature not being recognized. Codes often impose limitations and increased costs on builders and developers. Limitations may come in the form of building placement on property. Setback and clearance restrictions are imposed to allow for ladder truck access and space between buildings. Codes can also require built-in fire protection in buildings over certain square footages based on local ordinances adopting the code. In the wildland-urban interface areas, fuel modification may be required to be as much as 300 feet from the structure to prevent the spread of fire from natural vegetation to the structure. In addition, the installation of adequate water systems and fire hydrants is expensive, and many jurisdictions also charge permit and plan check fees. All of these requirements involve increased construction costs and use of available space. The need for codes has emerged from many disastrous fires that struck cities and wildland areas and exacted huge tolls and lives and property. Despite this, non-complying occupancies still exist, such as the Station Club nightclub fire of 2003, which resulted in a major loss of life. The Southern California fire siege of 2007 also demonstrate that when fuels, adverse weather, and structures are all in alignment, the losses will be dramatic. Although there are problems with enacting and enforcing codes and ordinances, the lack of or weak enforcement of codes can have catastrophic results. Let's talk a bit about the definition of laws. Laws are pieces of enacted legislation. There are different types of laws in the United States led by the United States Constitution, which no other laws may conflict. All legal authority for governmental action in the United States comes from the Constitution. The U.S. Congress passes legislation within the confines of the Constitution. Statutory laws are those that are adopted by Congress, which are called federal statutes, and those that have been passed by state legislatures, which are called state statutes. Statutory law also includes local laws, usually called ordinances. Codes are systematically arranged and are a comprehensive collection of laws. Regulations are rules designed to implement a statute based on an agency's interpretation of that statute. Such rules provide procedural requirements for program operations. Typically, they are published through an official process that allows for public comment. Regulations have the same effect as law and must be complied with once they are in published final form. The federal government organizes its statutes applying to a certain subject by placing them in the Code of Federal Regulations, or CFR. States do much the same thing. The laws regarding public safety may be in the Health and Safety Code. Criminal laws are organized into the Penal Code. Examples of codes that are adopted by local government ordinances are the building and fire codes. State laws can augment or increase provisions in federal law, but they cannot weaken the federal law. The same relationship exists between local ordinances and state or federal laws. Federal regulations and state legislation are not the same as adoption by ordinance of a building or fire code. The constitutionality of laws is determined by the judicial system. When a law or the enforcement of a law is questioned, it may be taken before the courts. Once these issues are decided, the rulings are referred to as precedents. These precedents are used as the basis for future interpretation and enforcement of the laws. Laws are applicable only if they have been properly adopted and not been reversed by a court decision. Through court decisions, laws are changed, in some cases suspended, until a final decision is reached. In modern times, initiatives passed by voters may create a law whose enforcement is held up in the court system for years. Appeals may be made at a successive level until the Supreme Court agrees to hear the suit or refuses to hear it, thereby leaving the decision of the next lower level of court standing. It's usually a U.S. Court of Appeals, which is divided into 9 districts. When the law is not specific in a matter, the laws and previous court decisions are reviewed to determine what is most closely the intent of the law. In some states, in lieu of an existing law, a legislative council or attorney general's opinion governs conduct, action, or procedures. It is important to have a good idea of what the applicable laws are in any situation. Firefighters are charged with the authority and responsibility to enforce laws only that exist, not just what they think is a good idea. When you, acting under the authority of your position, tell a business or property owner to make a correction, they have 2 choices: to go ahead and do it or to challenge you. They can say they want you to cite the provisions of the code that requires them to make such a change. If you are not familiar with the code and you are wrong, they have every reason to contact your supervisor and report your inadequacies. However, if you know the regulations, you can produce the code section that requires compliance with your orders. A third alternative is for them to let you go ahead and issue the citation and take the matter before the judge. What they will ultimately have to do depends on the decision rendered by the court. In some circumstances, the word of the fire department employee is not the final word, no matter what the law says. A business owner may be granted a variance to avoid complying fully with the letter of the law, which can be granted for a number of reasons. The code allows variance provided the intent of the code of provision is met. A variance allows the business owner an alternative to meeting the strict letter of the code as long as life and fire safety are provided. At other times, the variance may be granted for political or economic reasons. Before discussing the court system and its organization, it is necessary to understand the concept of jurisdiction. The cases that a court can hear are considered to be within its jurisdiction. Original jurisdiction is when a case can be first heard in a certain court. When the case must be heard in a lower court and then the lower court's decision is appealed to the higher court, the higher court is then an appellate jurisdiction. A fire department's jurisdiction is limited to the territory within which its authority may be exercised. For example, the city fire chief cannot go into a county fire department station and give orders to the firefighters because he is outside his jurisdiction. Jurisdiction is a very important concept to understand whenever talking about who can legally do what, where, and when. If you are acting outside your jurisdiction, you are not legally taking action, no matter how good your intentions. The court system is divided into 3 different levels. As you go up the levels, the matters brought before the court tend to be more complex, and the rulings are more widely applicable. The U.S. Supreme Court is the highest court on the federal level, and here's a picture of the building below in 11-1. Most cases heard before this court regard questions about the constitutionality of a law. The next lower level is one I mentioned before, which is the Circuit Court of Appeals. This court hears appeals from the federal district courts. The federal district courts deal with matters of federal law. So at that same level, you have the U.S. District Court of Appeals and the federal district courts. They are on the same level. One is appeals court and one is a rulings court. When a crime is committed on federal property, the accused person must appear in federal district court because the act occurred on federally managed land. On the state level, the highest court is typically the state Supreme Court. This court usually hears appeals from district courts of appeal. The district courts typically hear appeals from the district or superior courts. Depends on the state. They're called different things. The district or superior courts are where most of the state trials are heard. For example, a case of arson. Some cities and counties have municipality or county courts where the misdemeanors offenses are heard, with the exception of those committed by juveniles, which are heard in district or superior court. If you wrote someone a citation for an illegal open burning of trash, he or she would be required to appear in municipal court. If someone were arrested for possession or discharge of illegal fireworks, a felony in some states, he or she would appear in superior court. Both situations may start with the issuing of a citation, but the offenses are very different in the eyes of the law. There are two kinds of action that may be taken into court of law in regard to liability. One is criminal, where accountability is sought under criminal law. Criminal cases are prosecuted by an attorney general or district attorney in an attempt to prove that a crime has been committed. A crime is defined as an unlawful act as described in the criminal codes. The other kind of liability is civil liability. The purpose of civil liability is to recover any losses incurred by injured parties and create behavioral changes in defendants. Civil courts can award compensation for damages to an injured party, which is the plaintiff, from the person causing the injury, which is the defendant, and divide and assign a degree of responsibility for the damages incurred in cases involving multiple defendants. A person or organization does not need to be found criminally liable to be held civilly liable. For example, a defendant may be acquitted of murder in a criminal trial, but be found civilly liable in an unlawful death civil lawsuit. The O.J. Simpson situation is a perfect example of that. He was found innocent in criminal court, but he was found guilty in civil court. So there is a perfect example of how that system works. Now, in regards to lawsuits, we live in a society where lawsuits are becoming increasingly common. When someone's house burns down, for example, they may file a claim against the fire department for not saving it. This claim can be litigated as a civil suit. Of course, it's not criminal, unless nobody ever responds. But that obviously is 99.9% of the time not the case. The jurisdiction may be able to settle out of court. The way to avoid lawsuits is to do your job correctly every time. So you're ready, responsive, and there in a timely fashion. So long as you do that, any lawsuits brought are going to be thrown out most of the time. So there's a good example of why you need to be always training, always ready, be prepared to fall back on your training depending on what you encounter, and always be ready to respond in a very timely fashion. Should your actions result in someone filing a claim for damage for a lawsuit, you will most likely be questioned regarding industry standards, department standards, which are policies and procedures, and your knowledge of department standards. When I said be ready, this is one of the things that I say be ready about. Don't just have your turnouts ready and be ready to hop on the engine and spray everything with a hose. You also must know policies and procedures and be responsible for your actions. And you sure don't want to find yourself in a courtroom in a chair trying to defend actions that you should have been aware of, but were not. And so your specific actions wound up causing damage. Your training, which is one thing I just mentioned, and also whether you were acting within your scope of employment. So that is something that will be drilled down hard. That's one reason we spent so much time talking about different levels of authority in the fire department in the chain of command and your specific roles and responsibilities. You may know or have knowledge beyond your specific assigned roles and responsibilities, but you're not legally allowed to act upon those until you have certified that you're properly trained in that knowledge. And again, this is finding yourself in a witness stand is not where you want to try to explain, well, I knew what to do, so I just went ahead and did it. And so you're knowing your roles and responsibilities. That's policies and procedures, knowing your specific duties, doing regular training revolutions, etc. Taking incidents and learning from them. All of those play a very important part for you, not only in daily performance, but God forbid if you find yourself in a courtroom on a stand being cross-examined. You will be ultimately judged on whether you were exercising reasonable and prudent judgment. You must also take the time to document, through the use of reports, what you did. When lawyers approach the jurisdiction to start a suit, the evidence of a job done correctly and properly documented can often stop the proceeding in its tracks. So one of the reasons that English is stressed so significantly in all of the fire classes is because of this right here. Every document you fill out is a legal document. People use it for budgetary purposes, for legal purposes, for insurance purposes, etc. I saw one report recently and the name of the homeowner wasn't listed on the fire report. So if he took that to the insurance company, they'd say, well, who are we supposed to pay? So that just halted everything. So make sure that your English is great, that you're able to file reports completely and thoroughly, etc. When a civil suit is filed, it is because of a tort, which is the legal term for a wrongful act. The term tort is only used in civil court, however, not criminal court. Civil actions are brought within the intent of seeking monetary compensation. Tort can result from nonfeasance, misfeasance, or malfeasance. Nonfeasance is a failure to act. For example, you respond to a medical aid incident and fail to splint a broken leg before the victim was moved, causing further injury to the victim. Misfeasance is doing something wrong that you are lawfully allowed to do. One example is, although responding with red lights and siren releases you from obeying traffic laws to a certain point, it does not allow you to run stop signs at a high rate of speed without due regard to public safety. This is specifically specified in many departments' standard operating procedures and guidelines. Malfeasance is wrongdoing or conduct. For example, you drive the engine to a fire while intoxicated. Driving under the influence is illegal, and furthermore, an impaired firefighter should not respond to an emergency. The defense that you were just doing the best you could under the circumstances is often not good enough, as I carefully explained a short time ago. When things do go wrong, it is our responsibility to find out what went wrong and take measures to prevent a recurrence. The ability to perform properly at incidents comes from experience and training. In many cases, you may lack the experience. If you paid attention to the training and practice, you should be able to perform as expected. If not, your performance will be below that which is expected, and you will have a hard time defending your actions in a court of law. The training must also be documented. Judges and juries are suspicious when documentation of training is completed, but is not available when requested. One of the ways to address issues such as lacking experience or training is through policies. Policies clarify or provide direction for specific situations, and these policies must be agency-specific and regularly reviewed to ensure that they are still valid. The policies must be written and delivered to the members of the department so they are understood. The department must be able to verify that they have been received, and all personnel have not only seen them, but understand them well. And the only way to verify understanding is through regular testing. All personnel in a supervisory capacity must follow the policies and set the example if they expect others to do the same. There are several simple policies you can use to limit your liability and help protect yourself against a lawsuit. Develop a reminder process that will send up a notice when it is time to go back to a business to re-inspect for previous problems. Conduct the most thorough inspection you are capable of. Maintain accurate records of your inspections, variances, complaints, and so forth. Have someone with you when making your inspections, preferably an employee of the owner or business. Remember, this action will not eliminate the possibility that someone could still accuse you of misconduct. If you are refused entry for an inspection, obtain an inspection warrant. Finally, treat all people fairly and honestly to eliminate the potential of a business owner claiming that he or she was being discriminated against. The public expects you to do a job and do it well. It is the responsibility of every firefighter to perform to the best of his or her ability and perform correctly. Most departments have a standard procedure for complaints brought against members for complaints by the public or other members of the department. An example of standard procedure is as follows. The person wishing to file the complaint should speak to the accused supervisor or the fire chief. The complaint is discussed with the appropriate officer who explains the options available for the complainant. If the complainant decides to pursue the matter, the personnel complaint form should be completed. The form is forwarded to a fire chief or designated employee, and a decision is made as to the correct investigative procedure based on the nature of the complaint. At the conclusion of the investigation, a determination is made as to the disposition of the complaint and what action, if any, is warranted for an employee. The person complaining is notified by mail in writing of the results of an investigation, as is the accused. The person making the complaint should be assured that the complaint will be properly investigated. Also, the department should make sure that no adverse consequences occur to any person or witnesses as a result of having brought a truthful complaint or provided truthful information in any investigation of a complaint. It is standard policy that any employee who attempts to discourage, delay, or cover up any complaint received by a citizen shall incur disciplinary action. It is the complainant's responsibility to be truthful and accurate as possible in presenting information that he or she believes should be investigated. The complainant should understand that malicious or false complaints against departmental personnel could subject him or her to possible criminal and or civil action. The department may also assist in pursuing such action. The complaint form should state that the person signing the complaint does affirm under penalty of perjury that the facts contained therein are truthful. The federal government and the courts hold management responsible for harassment in the workplace. A clear understanding of what constitutes harassment is essential to the development of a harassment-free work environment. Harassment is defined as coercive or repeated, unsolicited, and unwelcome verbal comments, gestures, or physical contacts, including retaliation for confrontation or reporting harassment itself. Harassment includes physical conduct, which constitutes unwelcome touching, standing too close, inappropriate or threatening staring or glaring, and obscene, threatening, or offensive gestures. Nonverbal or written conduct can be inappropriate references to body parts, derogatory or demeaning comments, jokes or personal questions, sexual innuendos, offensive remarks about race, gender, religion, age, ethnicity, sexual orientation, political beliefs, marital status, or disability, obscene letters or telephone calls, catcalls or whistles, sexually suggestive sounds, loud, aggressive, inappropriate comments, or other vocal abuse. Then there is visual or symbolic conduct. This would be display of nude pictures, scantily clad or offensively clad people, display of intimidating or offensive religious, political, or other symbols, display of offensive, threatening, demeaning, or derogatory drawings, cartoons, or other graphics, offensive t-shirts, coffee mugs, bumper stickers, calendars, or other articles. As far as the work environment is concerned, any area where work employees are or work-related activities occur, including field sites, fire stations, buildings, facilities, and vehicles or other conveyances that are used for travel, are limited to professional behavior and appearance only. As far as responsibility lies, managers, supervisors, and employees as well as contractors, Cooperating agency personnel and volunteers are all responsible for creating and sustaining a harassment-free environment by their individual conduct, through which job supervision, coaching, training, and other behavior and means take place. All employees, contractor personnel, and visitors must take personal responsibility for maintaining conduct that is professional and supportive of this environment. Employees who witness harassment are instructed to report it to the proper authority. Individuals who believe they are being harassed or retaliated against should exercise any one or more of the following options as soon as possible. Tell the harasser to stop the offensive conduct. Tell an officer or supervisor about the conduct. Contact the fire chief or any other individual who would take action. For example, a union representative or the agency equal employment opportunity representative. The Fire Prevention Bureau has the legal responsibility and authority to enforce fire-related codes and ordinances. However, the fire department and its personnel cannot demand that action be taken by a property owner unless there is authority to inspect. The most often cited case in relation to fire prevention is C versus the City of Seattle, 1967. In this case, the U.S. Supreme Court held that administrative entry without consent of the portions of commercial premises that are not open to the public may be compelled only through prosecution or physical force within the framework of a warrant procedure. Recommendations are given to fire inspection agencies to assist fire inspectors in operating within the guidelines set forth by the U.S. Supreme Court. Inspectors must be adequately identified by wearing some type of uniform, such as a blazer, and inspectors must state the reason for the inspection, and it should not be framed in any type of joking way. Inspectors must request permission for the inspection. There are times that are inconvenient for the occupants to undergo such an inspection. They should make arrangements for the inspector to come back at a more convenient time. Inspectors should invite the person in charge to walk along during the inspection. This is a good opportunity to point out problems, ask questions pertinent to the inspection, and discuss voluntary compliance with the required changes. You must remain professional at all times and complete the inspection, and the persons at the business have to work to accomplish this as well. Inspectors should carry and follow a written inspection procedure, making it less likely to overlook something important. Inspectors should request an inspection or administrative warrant if entry is denied. This will very rarely be necessary, however. If all other methods of gaining voluntary submission to an inspection fail, then an inspection or administrative warrant will be necessary. Inspectors may issue stop orders for extremely hazardous conditions, even if entry is denied while warrants are being issued. Inspectors should develop a reliable record-keeping system of inspections. The inspector can update information such as phone numbers and contact persons, owners and business name information, and records of past violations. If the system of voluntary compliance is used, it is important to know when re-inspecting whether the last violations were corrected. If they were not, stronger measures may be required to ensure future compliance. Inspectors should have guidelines available that define the operations without a search warrant or obtaining permission to enter. These guidelines are necessary. If you shut down an operation, you are costing the business money, and it may well result in a lawsuit. It is important that these procedures be applied uniformly and impartially. Inspectors should be sure that all licenses and permits indicate that compliance inspections can be made throughout the duration of the permit or license. Before any inspection is made, the inspector must be sure that he or she has the right to inspect the premises. Inspectors must be trained in fire hazard recognition and in applicable laws and ordinances. It is your responsibility to make a thorough professional inspection. Ignorance of the law is no excuse for either party, you or the owner. If a fire results from something you overlooked or failed to enforce, you could be held liable for fire, injury, or death. For this reason, personnel assigned to the Fire Prevention Bureau receive special training and inspect the more complex businesses and processes. Personnel on engine companies are not as highly trained and in most cases perform the less complex inspections. As an inspector, you need to possess the technical expertise to identify physical, procedural, and structural illegalities. Examples of physical illegalities include substandard electrical installations, excessive amounts of flammable liquid stored, and lack or inoperative fire extinguisher. Examples of procedural illegalities include failure to obtain required permits for hazardous operations, unsafe welding activities, improper smoking areas, and unrestrained flammable gas cylinders that may tip over. Examples of structural deficiencies include inadequate or breached firewalls, improper fire exit design, and improper installation of fire doors. The state fire prevention laws and codes are based primarily on model national codes. In some states, the codes are divided by type, such as a building code, health and safety code, welfare and institutions code, and administrative code. In most states, the state fire marshal interprets and recommends state-level legislation as it relates to fire and life safety. The state fire marshal may also be charged with the responsibility of enforcing regulations and codes in state buildings and in areas with no established fire prevention bureau, such as rural areas. The state fire marshal may delegate authority to the local jurisdiction when there is an established fire prevention bureau, usually in a county, city, or district fire department. The state fire marshal can delegate authority to perform these inspections, but still retains the responsibility to see that they are completed. On the local level are the fire departments and local codes and ordinances. Most jurisdictions adopt model codes through ordinance. These codes may be adopted in part or in whole as the local jurisdiction wishes and finds politically acceptable. Adoption of the Fire Prevention Code usually designates the fire chief as the primary enforcement authority. The chief then delegates that authority to the fire marshal and inspectors. Adopting a model code does not mean that the jurisdiction cannot establish ordinances that are not addressed in the model code to deal with particular local problems, such as weed ordinance or regulation in high-rise buildings. It is the responsibility of the local governing body to enact the required legislation through ordinance to make these requirements into law. Now let's talk about the relationship of federal, state, and local regulations. When discussing the relationship of federal, state, and local regulations, the subject of jurisdiction comes into play. The jurisdiction is the limits of territory in which the authority is exercised. Territory is not strictly geographical, however, it can also apply to situations. When several levels of laws are encountered, usually the most stringent law is the one that is enforced. This is not always the case, especially when different levels of government jurisdiction are involved. For example, a fire prevention person for the Forest Service would enforce federal regulations on federal lands, but he or she would not perform a prevention inspection in a business in a city. A local fire department would not have jurisdiction in a federally owned post office, but if a fire were to occur there, it is the local fire department's responsibility to respond. The jurisdictional lines can somewhat become blurred. For example, the local fire department does have jurisdiction over a contract post office operated from a privately owned building, which is common in a suburban or a rural area, or when there is a locally protected housing area on private land in the middle of a national forest. The fire department and the forest agency should work together on hazard reduction to prevent a structure fire from spreading to the forest and vice versa. The state fire marshal usually has jurisdiction in state-owned buildings such as prisons and government office buildings. The state fire marshal may make an agreement that allows local fire department to enforce state regulations in certain occupancies. Other governmental agencies are involved as well, such as the local zoning commission, which regulates what types of occupancies are allowed and where, such as a high hazard occupancy that cannot be situated in a residential area, etc. The local building department, and they are responsible for enforcement of building codes, plan checks, and the inspection of buildings during construction, whether it is new construction or remodeling. And it also determines occupancy types allowed in buildings depending on construction type. For example, a building that was originally a restaurant may not be allowed to be used as a cabinet shop without major modification. In the average jurisdiction, the building department may be aware of remodeling only when a building permit is requested, whereas the fire department makes periodic inspections of businesses and is more likely to discover evidence of changes. When the fire department discovers alterations or changes in occupancy, it should notify the building department and work with their staff to ensure that the facility complies with construction, fire, and life safety regulations. Some problems are beyond the legal authority of the fire department to handle. It is important for fire department personnel to know where their jurisdictional authority begins and ends. The violations found may not be of the fire code, but rather a building code or other ordinances. In these circumstances, personnel must know how and which department to make a referral to. For example, an abandoned house, which could present life and health hazards, may not fall under provisions of the fire code, so a referral would need to be made to the building department itself. It is also good public relations to have a working knowledge of the responsibilities and jurisdictions of the local public agencies. That way, when someone calls to complain about an eyesore, such as a neighbor's accumulation of trash in his or her yard, you can assist in resolving the problem by making a referral that handles the problem. The person who complained will remember that you, the fire department, were of assistance. By working together, the fire department and other public agencies can assist each other and perform their functions to the public's satisfaction. Now let's talk about model fire codes. There are several organizations that have developed model fire prevention codes, including the Building Officials and Code Administration, which is BOCA. They publish the Basic Fire Prevention Code. The International Conference of Building Officials, ICBO, publishes the Uniform Fire Code. The Southern Building Code Congress International, or SBCCI, publishes Standard Fire Prevention Code. The NFPA publishes a series of codes and standards known as National Fire Codes. For example, NFPA 1, which is the Uniform Fire Code. The three organizations, ICBO, BOCA, and SBCCI, recently teamed together to create a nationwide fire code together with the nationwide building code that go hand in hand with the fire code itself. The use of a nationally recognized model fire prevention code is usually more desirable than a locally written code. This is because model codes have been nationally developed and represent a broad spectrum of fire prevention experience. Additionally, nationally recognized codes give building experts such as architects and engineers a familiar base from which they can design a structure's built-in fire protection features, and it offers a means to gain formal interpretations of the code's intent if a local inspector does not clearly understand a particular code requirement. Also, it requires that they undergo a constant review process with a new updated edition published every 3 years, which makes them more in line with current fire protection theories and technology. Perhaps one of the most important factors in adopting one of the model codes is that they are in companion codes to the publishing organization's building codes. This minimizes the likelihood that there will be conflicting code requirements. The model fire prevention codes are typically divided into sections or chapters that deal with certain topics of fire protection. The first chapters typically deal with administrative items. Then the codes typically define the authority of the fire official and define the responsibilities of property owners to maintain their premises in a fire-safe condition. The next section that typically follows defines the fire protection terminology used in the code. The following chapters typically deal with proper installation and maintenance of fire protection features. Lastly, they offer specific requirements for the use and protection of fire equipment, processes, occupancies, and hazardous materials. Many jurisdictions have, by ordinance, adopted the NFPA's National Fire Codes. This has the positive effect of having almost any fire protection problem covered by a code or standard. However, it also has the disadvantage of making the inspector responsible for the knowledge and research capabilities to understand many separate fire protection regulations. It is important to understand the difference between a code and a standard. A code is written in language that mandates what should be done and is written such that it can be enforced as law. A standard, on the other hand, expresses how something should be accomplished and is typically written as a set of recommendations. In other words, the codes stipulate when to install a fire sprinkler system in a particular building, and the standards address how to design and install the sprinkler system. When standards are adopted as part of an ordinance, these recommendations have the force of law and may be enforced as such. When a certain model code is adopted, it is imperative that a certain edition or year be adopted. It is illegal for the ordinance simply to state, adopt the most recently published edition of a code, as this denies the public its right to due process. The specific edition must be identified in the ordinance. A building built under an older edition of the adopted code is subject to that code and not necessarily to the latest edition of the adopted code. This often changes when a major renovation is done on the structure. As part of that process, the building must be brought up to code to meet the new code. A building that was constructed prior to the adoption of the new code but is compliant under the code existing at the time is referred to as existing non-conforming. Now let's talk about occupancy classification. When the building or fire code is to be applied, the occupancy classification is the first thing that must be determined. It is important to select the classification that most accurately fits the use of the building. Most requirements of the code come from this classification, which you see here in table 11-1. You will also find this in your text. Many of the occupancy examples have subcategories which vary from code to code. An assembly occupancy may be subdivided based on the size of the occupant load or the type of use, such as a restaurant or theater. Educational occupancies may be subdivided into regular schools and daycare centers. Institutional occupancies may be subdivided into restrained or non-restrained occupants. Residential occupancies may be subdivided based on the number of units or the type of residential setting, such as a dormitory, board and care, hotel, motel, apartments, etc. Storage occupancies may be subdivided based on the combustibility of contents or their fire load that is stored in the building itself. The classification of the occupancy is important for many reasons. The building code requires limits as to the height and area of a building depending on the occupancy classification and the types of construction materials. Generally, the more fire resistive the structure, the larger it is permitted to be. Additional areas may also be added if a building is protected throughout by automatic fire sprinklers. It is important from a building code standpoint to determine the occupancy of a building so that the mixed occupancy fire separations can be determined. For example, a model building code may require only a 1-hour fire rated separation between a business such as an office and a mercantile such as a clothing store usage. Then there are construction types. Both model building codes and NFPA 220, which is the standard on types of building construction, can be used to determine the type of construction used in a building. This type of construction is typically denoted by a shorthand notation such as type 1, 2, 3, 4, and 5. It may also be followed by a number or letters such as type 4-2HR or type 4 unprotected. And you see an example of this below in figure 11-2. These notations and numbers refer to what the building is constructed of and what the hourly ratings of its structural members are, such as columns, beams, trusses, and roofs. The Model Building Code determines how close buildings of a certain construction type can be from another building or a property line. The Model Building Codes and NFPA 101, which is the Life Safety Code, determine other important factors such as the occupant load of a structure, the size of the means of egress, and the number of exits. For multi-story buildings, the codes require certain hourly ratings around stairwells and building shafts such as trash chutes and elevator shafts. The codes at times mandate the installation of fire sprinkler systems, fire alarm systems, or standpipe systems. They can also be used to determine the need for emergency lighting and exit signs. These items are only a brief overview of complex codes and interpretations that can be up to 1,000 pages long. Codes are most often developed in response to a disaster, unfortunately. After a major disaster that could have been prevented, there is a public outcry as to why it was not prevented. The fire codes requiring the exits open outward and be kept unlocked were developed after numerous multiple lost fires. Building codes requiring enclosing shafts in fire-resistive construction were the result of rapid fire spread in buildings caused by unprotected shafts. Structural steel is commonly covered with fire-resistive coating or materials such as gypsum board, and codes are developed by recognizing the need for increased public safety. Legislation that sets the groundwork for the process to begin is sponsored and passed. Public input is sought and ordinances are written in answer to the needs and to the input. Examples of this process are public right-to-know laws. This was enacted after it was discovered that many businesses were storing large amounts of hazardous materials on their premises. Oftentimes, these businesses were operating close to residential areas and schools. After a few major incidents, the public came to realize the need for disclosure of just what was being stored, manufactured, and used in their neighborhoods. These laws require businesses to disclose through a business or management plan and hazardous materials inventory the materials that they have on site and their use, method of storage, and location. Codes are written as bodies of regulations that can be adopted in whole or in part by ordinance. Standards are a recommendation on how things should be designed or done. They are usually adopted by policy or as part of a memorandum of understanding. The NFPA has many standards that are used in the design of fire apparatus and other equipment. Most fire departments specify that the equipment they are ordering must meet the current applicable standard requirements. Manufacturers, in turn, design their equipment to meet the latest standard. When a standard is adopted as part of a memorandum of understanding between a jurisdiction and its employees, the items referred to must meet the standard. An example of this is the adoption of NFPA 1500, which is the Fire Department Occupational Safety Health Program. When the standard is adopted in whole, all equipment brought by the department needs to meet the standard. It may go as far as to state that all equipment does not meet the standard will be replaced by a specified date. Standards are usually adopted as a matter of policy instead of by ordinance. This adoption method recognizes their use without having the force of law. In many jurisdictions, agency in charge of the emergency scene is determined by law. Some states recognize the public agency with primary investigative authority as the scene manager. In the absence of a representative of the agency with ordinary or primary investigative authority, the highest ranking member of the public safety agency at the scene will be the scene manager. Once the agency with primary investigative authority arrives, the individual from that agency assumes scene management authority. In the case of traffic accidents in a city, the agency with primary investigative authority is the local police department. On state and federal highways in rural areas, this may be the State Highway Patrol. When the fire department arrives before law enforcement, they assume scene management responsibility. Responsibility for scene management would then be transferred to the agency with primary investigative authority when a member of that agency arrives on the scene. For practical reasons, when the incident is primarily based on functions provided by the fire department, such as vehicle fire, hazardous materials incident, or vehicle rescue, the law enforcement agency may relinquish command of the incident to the fire department, or the fire and law enforcement persons in charge or incident commanders may participate in unified command at a particular incident. It is important to know and establish who has scene management authority because that agency is the lead agency and ultimately responsible for the incident. 29 CFR 1910, which is the Occupational Safety and Health Standards, operating in immediately dangerous to life and health, or IDLH atmospheres, came about on May 1st, 1995, when the Occupational Safety and Health Administration, or OSHA, issued compliance instructions for states recognizing OSHA standards. This was done to ensure uniform enforcement standards for all workers operating in atmospheres that are immediately dangerous to life and health, or IDLH. Title 29 CFR Part 1910 requires that firefighters involved in interior structural firefighting operations be provided with and use self-contained breathing apparatus, SCBA. The regulation also specifies that all firefighters involved in interior firefighting and utilizing SCBA shall operate in a buddy system with 2 or more personnel, commonly referred to as 2 in, 2 out, as you see demonstrated below in Figure 11-3. The firefighters operating in the buddy system shall be in direct voice or visual contact or tethered with a signal line. Radios and other means of electronic contact shall not be substituted for direct visual contact for employees within the danger area. To account for and be available to assist or rescue members of the team working in the hazard area, identically equipped and trained firefighters are required to be present outside the hazard area prior to the team entering. During the team's work in the hazard area, a minimum of 4 individuals is required, so there are 2 individuals working as a team in the hazard area and 2 individuals present outside the hazard area for assistance or rescue at emergency operations where entry into the danger area is required. One of these outside firefighters may be assigned to other duties such as incident command, and the other can have no responsibilities other than to account for the team inside. What this means to you as the firefighter is that you are not advised to make an interior attack on a fire structure with only 2 or 3 trained firefighters at a scene. Every reasonable attempt must be made to provide a minimum of 4 personnel at the scene. The 2 who remain outside must be identically equipped with full PPE and SCBA. One of those remaining outside must stay in direct contact with the entry team. The other may have other duties but must stay available to assist if necessary. The total number of personnel required at the scene increases to 5 when 1 is assigned to operate the pumper, 1 is assigned to incident command, 1 is the contact person, and 2 are inside. This is typically not a problem for larger departments, but it can be a problem for departments in rural areas or volunteer fire companies that have only 2 or 3 personnel at the scene with additional assistance 15 minutes or more away. The regulation does allow entry with fewer than 4 personnel at a scene if a rescue is needed or if the fire is small and you feel as though you could extinguish it quickly with an interior attack. In these situations, you're faced with a dilemma. The only way you can literally stay within the regulation and still do the job that needs to be done is to change the atmosphere prior to entry. First, your very first operation may be to open the window to the fire area, making an indirect attack and knock down the body of the fire. Then ventilate the structure by placing a power fan in the doorway to remove the atmosphere immediately hazardous to life and health. In many instances, laws do not consider every possible scenario are enacted. 23 CFR Part 63.4, which is Firefighter High Visibility Safety Apparel, means that the Federal Highway Administration has initiated Title 23 Code of Federal Regulations Part 634 in an effort to protect the safety of firefighters, emergency medical responders, and other workers who work in the right-of-way of federally funded highways. The regulation states that all workers within the right-of-way of a federal aid highway who are exposed either to traffic, which is vehicles using the highway for purposes of travel, or to construction equipment within the work area shall wear high visibility safety apparel. Firefighters or other emergency responders working within the right-of-way of a federal aid highway and engaged in emergency operations that directly expose them to flame, fire, heat, and or hazardous materials may wear retroreflective turnout gear that is specified and regulated by other organizations such as the NFPA, National Fire Protection Association. Firefighters or other emergency responders working within the right-of-way of a federal aid highway and engaged in any other type of operations shall wear high visibility safety apparel. Definition of 634 Tac 2 within Part 634 cover what is meant by workers and high visibility safety apparel. There's a figure below that's 11-4. Any exceptions for emergency responders are incorporated into the definition of workers, meaning workers means people on foot whose duties place them within the right-of-way of a federal aid highway, such as highway construction and maintenance forces, survey crews, utility crews, responders to incidents within the highway right-of-way, firefighters, and other emergency responders when they are not directly exposed to flame, fire, heat, and or hazardous materials. Structural firefighting PPE is not considered to be highly visible safety apparel as it does not meet the standard as specified by ANSI/ISEA 207, which is the standard for high visibility public safety vests. NFPA 1901, which is the standard for automotive fire apparatus, applies to all fire apparatus contracted for, on, or after January 1st, 2009. The standard requires one traffic safety vest for each seating position, each vest to comply with ANSI/ISEA 207, which is the standard for high visibility public safety vests, and have a 5-point breakaway feature that includes 2 at the shoulders, 2 at the sides, and 1 at the front. As far as vehicle markings, NFPA 1901 requires the marking of the rear of the apparatus with retroreflective lettering and striping. Striping must be displayed in a chevron pattern with 6-inch wide strips sloping downward from the center point and covering at least 50% of the rear of the vehicle. Colors must be contrasting and only red, fluorescent lime, fluorescent yellow, or yellow colors are allowed. Additional retroreflective material may be used on the tail flap of the hose bed cover to enhance the visibility of the vehicle. Now let's talk about operation of emergency vehicles. In 1988, the federal government passed legislation that required all operators of vehicles over 26,001 pounds gross vehicle weight, or GVW, or towing trailers over 10,000 pounds to have a Class B driver's license. A normal automobile operator's license is a Class C. This legislation affected fire departments in that many fire vehicles weigh over 26,001 pounds. The Class B license requires a valid medical card that must be renewed every 2 years. A medical card requires a physical examination by a medical doctor. The cost of having to send all personnel for a medical exam every 2 years was seen as being prohibitively expensive for fire departments. After public agency lobbying of state legislatures, an exception was granted in many states, relieving firefighters of having to see a doctor every 2 years for the driver's license medical exam. In some states, firefighters can complete a medical questionnaire instead. Other states exempt firefighters from all Class B requirements. When members of the fire department are operating emergency vehicles on a non-emergency basis, they are subject to all the same traffic laws as the general public. When the vehicles are being operated as authorized emergency vehicles and are responding to emergencies, the laws specify certain exemptions. Usually, to be considered an authorized emergency vehicle, the vehicle must be equipped with a minimum of a siren and one steady burning red light to the front. Most state vehicle codes state that upon the approach of an authorized emergency vehicle displaying the required emergency warning devices, the driver of every other vehicle shall yield the right-of-way and drive to the right-hand side edge or curb of the highway clear of any intersection, stop and remain stopped until the authorized emergency vehicle has passed. When approaching an emergency vehicle parked at the side of the road with emergency lights flashing, drivers must slow down and move over to the outside lane, proceeding with caution until safely past the emergency scene. All pedestrians shall proceed to the nearest curb or place of safety and remain there until the authorized emergency vehicle has passed. One important fact is that the vehicle must be an authorized emergency vehicle. The fact that the operator is a firefighter does not create the assumption that the vehicle is authorized. This comes into question when volunteer firefighters respond to the station or the incident scene from home or work in their personal vehicles. They are authorized to respond as emergency vehicles only when properly equipped and when doing so is allowed under the state vehicle code. No state's vehicle code laws relieve persons operating an authorized emergency vehicle from the duty to drive with due regard for the safety of all persons and property. In effect, no matter how many red lights you display and how loud your siren, you are still required by law to drive carefully and defensively. In many departments, the policy is that you never exceed the speed limit by more than 5 miles an hour and that you come to a complete stop before proceeding for all red lights and stop signs. Many times at red lights at a cross street, the car in the lane nearest you will see you and stop, but the car in the farther lane will not see you and will not stop. When caution is not exercised by the firefighter driving the fire apparatus, a collision may result. Some firefighters assume that the display of red lights and siren gives them the right to drive as fast as they want anytime they please. This leads to what is called siren side. If there is a traffic accident, they will have to prove that they were operating the vehicle in a safe manner and that they were responding to a true emergency. Now let's talk about Good Samaritan laws. Numerous states have so-called Good Samaritan laws. These laws state that a person who voluntarily assists an injured person is not chargeable with responsibility for any errors or omissions in the care provided. This applies only if one is acting within the scope of one's training. For example, if you were to perform an emergency appendectomy on someone and you were only trained to the level of an EMT, you would be way outside the scope of your training and could be held liable for injury to the victim. However, if you're trained to perform a certain procedure, such as CPR, you can be held liable if you do not perform it correctly. In other words, you did not clear the airway properly before beginning CPR. You could also run into problems if you ask a person stopped at the scene of the traffic accident to assist you. When you do this without ascertaining his or her level of medical training, you should be very careful about what you ask him or her to do. You could be held liable if he or she were to take some action that the injured victim or himself or herself, because he or she would have been acting at your request. It pays to be careful and think before you act. Now let's talk about infectious disease. An issue that has become more prominent in the workplace is HIV, AIDS, and other infectious diseases. The Federal Rehabilitation Act of 1973 prohibits discrimination because of a handicap. The act applies to federal agencies and any organization receiving federal contracts in employment or the provision of services. In addition to covering people who are actually disabled, the Act prohibits discrimination against those who have a history of a handicap and those perceived as having a handicap. And the precedent for that is the School Board of Nassau County versus Arlene, a series of cases that have held persons with HIV that are protected by the Act. In 1987, the U.S. Supreme Court held that persons with contagious diseases were handicapped within the meaning of federal physical handicap statutes. In 1988, the Ninth Circuit Court of Appeals, Chalk versus U.S. District Court, found AIDS to be a contagious disease within the meaning of Arlene and therefore a handicap within the meaning of the Federal Rehabilitation Act. Law prohibits discrimination in employment because of race, religion, color, national origin, ancestry, physical handicap, some medical conditions, marital status, or sex of any person. Agencies have issued opinions that emergency medical care personnel have a responsibility to provide emergency medical care to a victim when responding to emergency and rescue incidents. Emergency care personnel cannot wait for mechanical breathing devices to start CPR, as this may further endanger the life of the victim. Therefore, many departments have issued each firefighter a small shield device to be used when performing mouth-to-mouth resuscitation on victims. These devices need to be carried at all times while you are on duty. In general, if you feel you've been exposed to an infectious disease, you can report it to the receiving hospital and it will notify the health doctor, or the health officer rather. However, the person you are treating does not have to undergo a test for HIV, AIDS, or other communicable diseases if he or she does not want to. Should the person choose to be tested, under confidentiality laws, the hospital may not be able to advise you of the results unless the victim agrees. In many cases, it is against the law to disclose to others information that someone is HIV positive or has AIDS. If you worked at a medical aid incident and the victim told you that she was HIV positive, that information is to be kept confidential. Writing the information on the board at the fire station or in any way advising people on other shifts is ill-advised. The absolute best way to avoid these problems is to wear your PPE every time you deal with victims, with no exceptions. Assume every victim contact is a possible exposure and protect yourself appropriately. Being able to get test results back from a victim from whom you suffered an exposure is no consolation. If he or she is HIV positive or has AIDS, finding out after exposure is probably too late to do very much good. Local jurisdictions have enacted AIDS-specific discrimination laws. These laws vary in their content and scope, and it is important that you become aware of them. Now let's talk about HIPAA, the Health Insurance Portability and Accountability Act. This act affects firefighters in their jobs due to their response to rescues and medical aid incidents. HIPAA states that health information regarding a victim can be given only to someone directly involved in the treatment of the victim. In a practical sense, If you are at the scene of a medical emergency, you are allowed to provide information regarding the victim's status only to the ambulance personnel or other medical care provider directly involved. This precludes you from providing medical information to the news media, law enforcement, and other personnel at a scene not directly involved with the treatment of the victim or bystanders. It also covers any victim care report or station logbook information that you may gather, as these records must be kept confidential. Now let's go over some summary notes for this chapter. Remember that codes and ordinances fall under the broad description of laws. Laws are written and adopted on all three levels of government: federal, state, and local. All legal authority for governmental action in the United States comes from the Constitution of the United States. In the case of fire departments, the meaning of their jurisdiction is the limits of territory within their authority that may be exercised. The way to avoid lawsuits is to do your job correctly every time. You must also take the time to document through use of reports what you did. The department should make sure that no adverse consequences occur to any person or witness as a result of having brought a truthful complaint or provided truthful information in any investigation of a complaint. The federal government and the courts hold management responsible for harassment in the workplace. Consequently, a clear understanding of what constitutes harassment is essential to the development of a harassment-free work environment. The Fire Prevention Bureau has the legal responsibility and authority to enforce fire-related codes and ordinances. When discussing the relationship of federal, state, and local regulations, the subject of jurisdiction comes into play. The benefit of creating a set of national codes is that building designers and architects can use the same set of regulations anywhere in the country. Codes are most often developed in response to a disaster. After a major disaster that could have been prevented, there is usually public outcry as to why it was not prevented. Codes are written as bodies of regulations that can be adopted in whole or in part by ordinance. Standards are recommendations on how things should be designed or done. In many jurisdictions, the agency in charge of the emergency scene is determined by law. Some states recognize the public agency with primary investigative authority as the scene manager. Standards have been put in place to promote personnel safety at incidents. Among these are the following: 29 CFR 1910, which is operating in IDLH atmospheres; 23 CFR 634, which is firefighter high visibility safety apparel; NFPA 1901, which is standard for automotive fire apparatus. When members of the fire department are operating emergency vehicles on a non-emergency basis, they are subject to all of the same traffic laws as the general public. When the vehicles are being operated as authorized emergency vehicles and are responding to emergencies, the laws specify certain exemptions. Numerous states have so-called Good Samaritan laws, which state that a person who voluntarily assists an injured person is not chargeable with responsibility for any errors or omissions in the care provided. An issue that has become more prominent in the workplace is infectious diseases. This issue involves people with whom firefighters encounter on an emergency incident, as well as firefighters themselves. Now, very nice work working through this and all lectures as one of the many tools for progress through this class successfully. Make sure to contact your instructor should you have any questions or need any clarification of the material in this chapter. Thank you, and we'll see you next chapter.